Hi everyone, welcome to this video on website terms and conditions. My name is Christina Carday. I'm a digital marketing master's student with Full Sail University. And today we will be discussing the proper inclusions in a terms of use or terms of conditions agreement, specifically for the Priceline.com website. So recently I was contracted to review the terms and conditions portion of the Priceline website for any revisions that may need to be made. Now Priceline is a very large company and their terms and conditions clause has several parts, which in turn has several subparts. So we're not going to go through the entire terms and conditions clause in this video. Rather, we're just going to focus on the part of the terms and conditions agreement which focuses on legal action specifically, which is part 1. So when looking at part 1 of Priceline's terms and conditions from a legal perspective, there are some specific questions we need to ask to ensure that the terms and conditions are what they should be. The first question is, are these terms of use policy a valid contract, meaning is it enforceable by law? In order to know this, we need to understand what the legal definition of a contract is. According to rocketlawyer.com, a contract is legally binding promise made between at least two parties in order to fulfill an obligation in exchange for something of value. Contracts can either be written or oral or a combination of both. So when it comes to terms and conditions, the existence of the agreement itself does not necessarily constitute a valid contract, but once acceptance of it is explicitly stated by the user, then it does. So for instance, if I log on to Priceline just to look around the website, kind of browse and check out prices, I'm not exchanging anything of value or acknowledging acceptance of any contractual terms. So that doesn't really fall into the necessary parameters for a valid contract. Now there is something called browse wrap, which could make browsing on a website contractually binding in certain circumstances, and we'll address that in a minute. Now, let's say I decide to actually purchase a ticket on Priceline. I have to click a box that says I accept the terms and conditions. Now, at that point, I'm exchanging something of value and I am entering into a valid contract. This is something legally known as click wrap, which basically means you clicked on the box, so you acknowledge the terms and conditions and you're bound by them in most cases. And usually a court will see this as a valid and legal contract. A great resource I actually found talking about click wrap is on pactsafe.com, which is a website that deals specifically with contracting valid contracts. So it's a great resource. You may want to check it out if you're interested in learning more about click wrap. But for the purpose of this video, just know it means if you acknowledge any website terms and conditions, in most cases, you're going to be bound by those conditions. So the second question we want to ask is, are site visitors bound to terms and conditions, or do they have to click the I agree button? Now, we addressed this a bit in the response to the first question, and the short answer is yes. Typically, a site visitor has to explicitly agree to terms and conditions in order to be considered as entering into a valid contract with Priceline or any other company. Now, there is a bit of an exception to this rule called browse wrap, which basically means just by browsing a website, a visitor is acknowledging and accepting the terms and conditions and is therefore bound by them. Now, where Priceline might think that's great for them, a court may not necessarily agree with that assumption. And unfortunately, there is very little case law that discusses that or corroborates that assumption. I did find one case dealing with browse wrap. It was Ticketmaster.com versus Tickets.com, in which Tickets.com used spiders, which are basically internet links, internal internet links, to extract certain information from Ticketmaster's website in breach of their terms and conditions agreement. Now, Tickets.com tried to use the argument that since they didn't acknowledge the terms and conditions agreement explicitly, they were not bound to it. However, the court disagreed with Tickets.com and said because they were aware of the agreement and they decided to breach the agreement anyway, they were therefore liable for breach of contract. So essentially, it looks like it comes down to, are you aware of the terms and conditions or not in browse wrap situations? And is that awareness in itself enough to bind you to those terms? So according to legal experts from Rocket Lawyer and also the American Bar Association, browse wrap situations are really going to be judged on a case-by-case basis, as there is no really concrete legal answer when it comes to this. So Priceline and any other company really has to pay close attention to these laws associated with browse wrap because they need to make sure their terms and conditions are drafted appropriately to accommodate this. The third thing we need to look at when considering the terms and conditions are lawsuits. So let's say, for instance, I was to have a dispute with Priceline, let's say for ticket fees or some other money they owe me. Per the terms and conditions, can I sue them? Now, most people will think, well, absolutely, you can sue because that's your legal right. Yes, technically that's true. However, if this is a click wrap case and I have agreed to the terms and conditions on the website, then technically I've agreed to handle any legal action in the manner dictated in that terms and conditions agreement. In the case of Priceline.com, they do have a pretty detailed legal policy when it comes to lawsuits and arbitration. Basically, the policy states that all users agree to allow Priceline to handle the issue first, either through their customer service channels, and if that doesn't work, then through arbitration first before pursuing any court action. Now, if you don't know what arbitration is, it's basically an agreement outside of court where a neutral arbitrator or official decides on the case. Now, Priceline also states that if arbitration is unable to solve the issue, or if for other legal reasons the matter needs to be escalated to a court level, they say that it needs to be handled in small claims court in the appropriate district. Now, of course, small claims court can only handle cases up to a certain amount of money. So once the case goes beyond that said dollar amount, it can't be handled in small claims court anymore. It needs to go to the district court level. So in Priceline's terms and conditions, it says, should that happen, the suit must be filed in the U.S. District Court of Connecticut, which is where the company is based out of. So the one thing that the terms and conditions forbids in any case is a class action lawsuit against the company. So there are parameters for bringing suit at the small claims level and the district court level, but when it comes to class action suits, the terms and conditions agreement basically says under no circumstances can any user file one of those. So there are different provisions for bringing suit against Priceline. However, in click wrap agreements, there is a certain hierarchy that needs to be followed when it comes to legal disputes. So the short answer is yes, you may be able to sue them, but you do have to go through the channels stated in the terms and conditions agreement if you did agree to that. So the fourth issue that we're going to look at is what changes, if any, would need to be made to the Priceline's terms and conditions. After taking a detailed look at Priceline's terms and conditions, there are two areas in particular that I saw that they probably need to take a look at to consider revising. The first is at the very top of the terms and conditions, right above the table of contents, where it says Priceline reserves the right in its sole discretion to amend, modify, or alter this agreement at any time by posting the amended terms on the site. Even though this is considered standard boilerplate language when it comes to terms and conditions agreements, there have been cases where this type of statement has caused a company to lose a lawsuit. According to Epic.org's Electronic Privacy Information Center, not only could you lose the lawsuit, but it could potentially nullify the entire terms and conditions agreement, depending on the circumstances. In Harris versus Blockbuster 2009, Facebook and Blockbuster had entered into some sort of business agreement where they were sharing private consumer information between the two companies for advertising purposes. A woman named Catherine Harris entered into a class action lawsuit and sued Blockbuster, stating that sharing her information was in violation of the Video Privacy Protection Act, which bans disclosure of a video renter's personal information. Now, Blockbuster tried to invoke its arbitration clause, saying that Harris could not sue them because she had agreed to the terms and conditions on the site, which forbade any class action lawsuits and also gave Blockbuster the right to change its terms and conditions whenever they wanted. Unfortunately for Blockbuster, the court sided with Harris, stating that Blockbuster had too much discretion in modifying their terms and conditions, and therefore the terms and conditions were unenforceable because they were illusory. So even though Priceline is pretty thorough in their legal policy, they do have similar language to that of Blockbuster when it comes to their right to change their terms and conditions at will. In addition, they also state on their site that all site users agreeing to the terms and conditions also agree to not bring a class action lawsuit against Priceline. So Priceline does need to take a look at this because there is case law precedent where the court has ruled against this type of language already. My advice here would be to just do away with this particular clause in the agreement altogether and consult the legal department on what to put in its place. The second area pertains to the manner in which users agree to the terms and conditions. When conducting a transaction on Priceline, it does require you to click the box stating you acknowledge the terms and conditions before conducting any financial registration transaction or any other transaction. But it does not require you to actually read the terms and conditions or at least access the page where the terms and conditions are found before clicking the box. According to classaction.org, this may cause an issue, particularly when it comes to language and arbitration agreements. So Priceline would do best to be extra thorough in this area by making sure all terms and conditions are communicated precisely on the site, and also that users are required to actually go to the page where the terms and conditions are located and scroll to the bottom before being allowed to click the I agree box. So at least they can make the argument they had to go to the page and read it, or at least scroll to the bottom acknowledging that they saw the terms and conditions. Outside of that, the rest of part 1 in Priceline.com's terms and conditions appears to be legally sound and well done. Just some adjusting of these couple areas can ensure the terms and conditions are strong against any potential legal action. Thank you for joining me for this video, and I will see you all again soon.